Welcome to today's program titled, What Did Overturning Chevron Deference Actually Change? Considerations for a Post-Loper Bright Administrative State. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, later in the presentation, we will read the CLE attendance verification code. Please write this code down, as it will not be reread, and it is required on the CLE credit request form. During the program, you will see a slide with a QR code that you may scan to access and submit your request for CLE credit. You can also find a link to the form in the connection details email you received this morning. A copy of the webinar recording will be distributed to all attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. This presentation has been prepared by Seyfarth Shaw, LLP, for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I would like to turn it over to our first speaker for today's program, Jules Levinson. Jules, please go ahead.
Thanks, Kate, and good afternoon, everyone. We are here to discuss, obviously, the Supreme Court's decision in Loper-Bright and how that impacted the administrative state and how it will impact the administrative state going forward. Next slide, please. So right now I'm going to be talking about an overview of Loper-Bright, and then we're going to be talking about what's the same, what could change, and some additional considerations. Next slide, please. So before I get into what Loper-Bright did, I'm going to set the stage on what the scene was before Loper-Bright. So for the last 40 years, courts reviewing administrative exercises of power, whether delegated from Congress or gap filling under potentially ambiguous statutes, were granted a certain modicum of deference to interpret ambiguous statutes and determine how they should be enforced and what they said. Under the prior regime in Chevron USA versus Natural Resource Defense Council, the Supreme Court set out a two-part test for how courts review administrative agencies' interpretations of statutes. Step one was, how was the statute that was in question ambiguous? If there was no ambiguity, then the courts would just go with whatever reading they held to be the unambiguous reading of the statute. Step two was, if the statute's ambiguous, did the administrative agency's reading of the statute result in a permissible outcome? So the administrative agency didn't necessarily have to have the best reading of the statute, but as long as the administrative agency interpreted the statute in a way that was consistent with the statute and could be reasonably squared with it, courts would have to defer, even if on their own review or their own interpretation of the statute starting from step one, the courts would have come to a different conclusion of what the statute meant or what the statute authorized. Loper-Bright changed all of that. Loper-Bright overruled the Chevron doctrine, overruled Chevron deference, and held that courts are no longer to defer in the same way to agency interpretations of statutes. Courts have the primary authority of interpreting the statute and determining what it means and judging agency action against that standard. So ultimately what Loper-Bright is a change in how courts look at agency action. It doesn't necessarily change what the agency has done or what the agency can currently do. It changes how courts look at challenges brought against particular agency action. One thing that the Loper-Bright court went out of its way to say is that, one, all decisions relying on Chevron type interpretations remain good law. So for the last 40 years, courts have been saying this agency action is good or this agency action isn't good. by using the deferential standard. Under Loper-Bright, all of those decisions remain good law, and the fact that they were decided based on a deferential standard doesn't change anything. The other point that the Supreme Court made is that those cases aren't subject to overruling just because they relied on the old standard. So if the agency promulgated a regulation, let's say, and that was challenged 20 years ago, and the court said, well, we don't think that's necessarily the best reading of the statute for the agency, you came up with a permissible interpretation, that law remains good until there's a subsequent challenge to a regulation or similar regulation on the same point. So from, as Rachel's going to get into and Carrie are going to get into a little later, from that perspective, nothing immediately changes for what an agency can do and what an agency is doing. Because anything that the agency could do before Loper-Bright, it still can do under existing law after Loper-Bright. Loper-Bright also cited approvingly the Supreme Court's prior decision in Skidmore versus Swift, where the court had granted a sort of lower level of deference to longstanding agency determinations that were grounded in thorough analysis within the area of agency expertise and were persuasive to the court. And it's not clear from Loper-Bright that that was overruled. And in fact, the citations in Loper-Bright to Skidmore deference suggest that agency interpretations, particularly where they're long-lasting, will remain a thumb on the scale for courts continuing to interpret and determine whether agency action complied with law. One example that I'd like to give of the change and not change of the standard of review under Loper-Bright are a couple of recent decisions out of district courts in Texas regarding the Department of Labor's rule for the meaning of what a fiduciary is under the Employee Retirement Income Security Act of 1974, ERISA. The Department of Labor has for years been trying to expand the definition of fiduciary, and in 2018, the Fifth Circuit struck down a 2016 rule on the basis that it was inconsistent with the statute, and did so under Chevron, the Chevron framework. And last week, two district courts in Texas temporarily stayed the successor rule that was put out this year by the Department of Labor. And while the courts relied on Loper-Bright to say that they had the final authority to say what the rule meant, they proceeded to rely on the Fifth Circuit authority from 2018 that was decided pre-Loper-Bright. So as much as things have changed, there is going to be a lot of continuity and analysis both pre and post Loper-Bright. And with that, I'm going to turn it over to Rachel.
Thanks, Jules. Hi, I'm Rachel C., Senior Counsel in Seyfarth's DC office, and I come to Seyfarth after over a decade of experience at both an NLRB and the EEOC running enforcement, management, and policy initiatives. So what I think we have a fundamental tension when talking about Loper-Bright and the end of Chevron deference is it is a big case. This is a big deal. We've upended a large body of administrative procedures law. You just sort of tear all of that stuff out of the casebook and go, what's next? On the other hand, whatever that big change is, the world keeps on turning. Enforcement processes keep on going, and the federal agencies, the enforcement agencies are continuing their business of enforcement. So if an employer is thinking of challenging enforcement or challenging a rule, the calculus is a little different, and we start parsing statutory delegations to the agencies, and we start thinking about, well, what would Chevron deference have even looked like? But on the other hand, your duties to comply with existing regulations, your duties under existing interpretations do continue. So that calculus does change, but the administrative state continues. So let's think specifically about the EEOC. Under Title VII, the EEOC only got procedural rulemaking authority under Title VII. And under existing Supreme Court case law, some of it very old. So we have GE versus Gilbert. There's no reason for you to know that one. That's from 1977, or EEOC versus Aramco from 91. That's old established Supreme Court case law saying that what the EEOC is putting out on Title VII doesn't get Chevron deference to begin with. They're explicitly getting Skidmore deference or something. It's like, yeah, the courts are going to look at it under, weighing it very much like Skidmore, reaching results that aren't with the thumb on the scale under Chevron. And in fact, the EEOC hasn't been trying for Chevron deference on its Title VII guidance, and I think there's much appetite or perception that even when the EEOC on some of its other statutes might have been entitled to Chevron deference, it wasn't getting it. So looking at employment discrimination laws on the employment side, on the civil rights side, really parsing what statute we're under and what the statutory delegation on rulemaking, or what kind of rulemaking or agency guidance we're looking at, or agency interpretation we're looking at, is now the name of the game. I think that if you look at the statutory delegations, the statutory text of the Age Discrimination in Employment Act, the ADEA, is a little bit different on delegating to the EEOC authority to issue definitions, to issue exemptions. And on the other hand, you have these other broad delegations in statutes that you have arguments about whether or not some interpretations fall in there, like we're doing with all of the, or looking at with all of these other regulatory agencies and their statutory delegations. One quick item by way of breaking news, we have the Pregnant Workers Fairness Act, the recently passed PWFA. And we had EEOC guidance, implementing guidance, interpreting the statutory text of the PWFA to include abortion care and things relating to abortion, with litigation about that. In the Eighth Circuit, just a couple of weeks ago, the red state attorneys general argued that the district court got it wrong by applying Chevron. And again, that's the district court applying Chevron to the PWFA when the EEOC wasn't even asking for Chevron deference in the district court to begin with. So there's this fairly complicated dance that's going on well, what are the compliance obligations, and what are the statutory underpinnings. As we get to the Department of Labor, and you think about all of the statutes that the Department of Labor enforces, whether it's the wage hour division, whether it's OFCCP on federal contractors, whether it's all those myriad of other statutes, some of these are very old statutes with ambiguity on what's delegated and what the scope of agency rulemaking is. And so that kind of analysis, I think, your existing, as an employer, as a contractor, your existing obligations continue, and the question is this more vulnerable to challenge? But until then, until that challenge gets resolved, you ignore that existing framework at your peril. The other thing I'd point out is the different kinds of agency action besides formal guidance issued under the Administrative Procedures Act, whether you have notice and comment rulemaking or other things, including sub-regulatory efforts. Some of that wasn't entitled to Chevron deference in the first place, and of course, much of what the EEOC was doing recently, while last year we saw a slew of formal guidance in previous years, we hadn't, and that was due to the political makeup of the commission. Speaking of politics and commissions and boards, I'm next going to turn it over to Carrie Burke, who's going to talk about the National Labor Relations Board. Thanks.
Great. Thanks so much, Rachel. So my name's Carrie Burke. I'm a partner in the Labor Management Relations practice. I sit in Atlanta. And as Rachel said, I'm going to talk about what has happened to the NLRB since Chevron and what we expect will happen thereafter. So let's just set the scene. To start, as with the EEOC, courts rarely relied on Chevron and granting deference to the NLRB's decisions. A couple of my colleagues, I'll shout them out, Mike Berkheimer and Jen Mora, did a deep dive into the statistics after the Loper-Bright decision came out. In the 40 years that we had Chevron on the books, circuit courts cited to Chevron 40 times in the 1,150 or so NLRB appeals that reached them. So that's approximately about 3% that the court was saying, yes, we'll rely on Chevron deference when affirming an NLRB decision. And, reading Loper too, just as a corollary to this, the court's reasoning in overruling Chevron really leaves little room for continued deference to NLRB decisions, except in very limited circumstances. The majority called out a decision styled NLRB versus Hearst that's all the way back from the 1940s. And in that case, the then Supreme Court basically said, we will grant deference to the NLRB as it relates to factual issues. And then the Loper court basically said, and that means not legal issues. Now, that said, setting aside Loper and ignoring Chevron for the moment, the Supreme Court in the 70s also issued a couple of decisions, one called NLRB v. Ironworkers, and the other one Ford Motor v. NLRB, where the court specifically said, we are going to be granting the NLRB, quote, considerable deference because those court majorities believed Congress had given the NLRB primary responsibility for interpreting the National Labor Relations Act and effectuating national labor policy. Now, that said, I think that line of cases is an open question in light of, I think, how strongly the Loper-Bright court said judges decide cases, not agencies. So that said, though, what is going to happen now? I mean, where we're at now, what does a snapshot look like? What precedent do courts of appeal look to when currently granting deference to NLRB decisions and rulemaking? And is that really going to change in a measurable way? Typically, circuit court precedent looks something like this. The applicable deference is going to be similar or has previously been similar, but in slightly different terms. So you've got the DC Circuit as an example that will uphold an NLRB proceeding unless the board acted arbitrarily or otherwise erred in applying established law and facts. Whereas the Third Circuit says something similar and will uphold the board's interpretation of the act if it is rational and consistent. That said, though, I mean, while we might get similar language going forward, I don't think that's a given. I think that Loper, particularly in the NLRB space, has given challengers additional weapons in their arsenal to say, you know what, while we understand this is the way things used to be, there has been a significant sea change in the way that agency decisions are viewed, particularly by this court, and it should be closer to de novo review than granting this wide degree of deference to administrative agencies. And so I think that's what we should expect going forward. And we've already seen several appeals filed in circuit courts that have made those sorts of arguments. Courts have yet to pass on those. I expect we'll start to see those decisions in the next 3 to 6 months. Now, again, what they say is an open question, but I would suspect we should start to see even less deference. Now, I do want to switch gears recently because while Loper, was very much a game changer for all of us, I think the other decision that's being talked about a little bit less is the Jarkesian SEC decision and its progeny, because in that case, some of you may recall, that was a Fifth Circuit case that ended up before the Supreme Court, and there were several really interesting open questions in it for us procedural and administrative nerds. And the first that was the only one the Supremes answered, which is whether or not the SEC, when imposing civil money penalties, had to bring those cases in Article III courts. And the Supreme Court said that they did. The interesting open question for me as an NLRB follower, and I think for others too as administrative watchers, is, what do you do and whether or not the Fifth Circuit got it right when they said that double-layer removal protections for administrative law judges that work for the SEC are unconstitutional. So that's a lot of words, and what does that really mean? Basically, it means that you have to go through 2 steps of for-cause findings before removing an SEC ALJ. And so the first step is this, ALJs under the SEC can only be removed by the Merit Systems Protection Board for good cause. That's step 1. Step 2 is this, though. MSBP members themselves can only be removed by the president for 1 inefficiency, 2 neglect of duty, or 3 malfeasance. That's it. So you've got to remove the MSPB member. and then remove the SEC ALJ. And that, according to the Fifth Circuit, is an unconstitutional double removal protection. Now, what's interesting here is the Supreme Court just refused to pass on that question. It didn't answer it up or down. And so for now, at least, that Fifth Circuit ruling is good law. And we are seeing attacks already on that point as to NLRB ALJs. And in fact, in one case, the NLRB members themselves. There are two cases now, one in Waco and one in Galveston, where those courts have enjoined the NLRB from prosecuting matters under the Act in front of the administrative agency against employers on the basis that the NLRB's ALJ's removal protections are unconstitutional, just like the SEC's. So the open question stemming from that is, if that's the case, where do all of these NLRB cases ultimately go? And quite frankly, we don't really know. It's a bit of a Wild West sort of situation, and we're all sort of figuring it out as we watch these court injunction decisions come through. And with that, I will turn it over to my colleague Leon to talk a little bit more about the immigration space and some more thoughts on Jarkezi as well. Leon, I can't hear you.
Thank you, Carrie, and thank you, Rachel and Jules, all three of you, for wonderful and informative presentations. I think having the cleanup speaker or the cleanup batter, if you will, speaking on immigration is perfect to illustrate sort of the import of Loper, Jarkezi, and some other very much related decisions that have emerged from the Supreme Court, both in this current term and in the last couple of years. And to put it in the crudest, most simplistic ways, if there are outcomes from federal bureaucracies that you don't like, that your company doesn't like, you will have many more avenues, procedural avenues, to challenge those outcomes than you did before. What is not going to change is federal judges. Federal judges will continue to bring their full menu of both personal biases, political biases, legal biases to the decisions, and they will find space within the formal end of Chevron deference to reach the outcomes that they want to reach. On the other hand, if there are things that you like that a federal bureaucracy is doing, and this is where immigration comes in, because immigration is a world where the federal government often taketh away, but it also giveth at times. You will find it harder to defend some of the things that the federal government does along those lines. And so if there are benefits, for example, that have been granted to particular classes of immigrants, or procedural leniency that has somehow been announced by one of the immigration agencies, it will become harder to defend those kinds of leniencies based on the doctrines that we're seeing. So I think that's a way in which immigration shows that it really will be very much situational, what the impact of the Loper and Jarkezi decisions will be. Now, let me talk about Jarkezi and another couple of decisions. Jarkezi, as Carrie shared, basically indicated that in situations like SEC enforcement for fraud that have parallels in what we call the common law, that those cases must be tried before a jury. Now, what Jarkezi leaves us very much at the ground floor is that if you read sort of the initial parts of Jarkezi, it's framed very much as being about the SEC and about the SEC's enforcement authority and its ability to conduct quasi-judicial proceedings. But if you read the whole decision, you realize that there are many openings for this to spread to many, many different kinds of administrative tribunals, whether they are in the Department of Labor or the EPA, the Department of Justice, just to name a few. These will become lines of attack for decisions by all of those administrative tribunals. But they also need to be seen in connection with a couple of other decisions that have come down from the Supreme Court in the last couple of years. The first is the Arthrex versus United States decision, which involved a challenge to actions taken by the U.S. Patent Office, and a finding that the U.S. Patent Office could not conduct internal adjudicative proceedings because Congress had not delegated adjudicative power to its presidentially appointed principal. And that unless that had occurred, they could not exercise that power. And that has now been extended in certain lower court decisions to the Department of Justice. And it is the kind of thing which, if taken together with Charchesi, you look at as the Supreme Court saying, we really want to put real boundaries around the ability of the federal bureaucracy to conduct adjudicative proceedings. We think they're taking our job as judges, essentially, is what they're saying, and they want to limit their ability to do that. And then there was another decision that also ends up, and this one is more recent, that really changes the landscape as well, and that is the Corner Post versus Board of Governors of the Federal Reserve System. And that one said that a party can challenge a federal regulation at the time that it is, or is within 6 years. The statute of limitations starts running within 6 years of the time that they are injured by that regulation. Now, previously, the rule of thumb had been that those 6 years generally begin to run at the time that the regulation is promulgated and goes into effect. What this now says is that the challenge could come many, many years after that regulation is issued, basically at a time when a particular party has a basis to challenge it. And I can tell you right now, we are here looking at particular areas where we're looking at potentially challenging regulations that were issued 2015, 2016, because in fact the injuries being experienced by our clients occurred now. And so again, take these all together, and while they're not going to change the existence of the administrative state, they are going to change very much the ability of the administrative state to operate. The other thing is that as federal bureaucracies now promulgate regulations, it's going to take longer, and they're going to have to work a lot harder to overcome the potential impact of all of these decisions. And so again, it really depends on what you want. If you would prefer a regulation not be issued, if there's a regulation that will make it harder for you to do what you do, then that's great. On the other hand, if there are regulations that lend certainty to a particular area of business or endeavor, that potentially could be something that is problematic. So with that, I think we're headed to the bottom of the hour. I want to thank everybody for joining us this afternoon. I'd like to read the CLE code, which is S as in Seyfarth, S as in Shaw, 2316. Again, SS2316, and you've got that nice little QR code that you can scan as well. And one last time, SS2316. And we have about 45 seconds left, so if any one of my co-panelists wants the last word, the floor is open. I think we've said enough, it appears. Is that right, Rachel?
Thanks, Leon. I appreciate it.
All right, everybody. Have a nice afternoon.
Good afternoon, y'all.